Good morning, everybody. Thank you for joining us today. It is Saturday, February 23rd, 2019. My name is Carol Werelius. My partner, Jim Knox, will be joining us soon, as well as my friend Judy, who most of you are familiar with, I'm sure. I have to say we are not accountants, tax professionals, lawyers, or investment advisors. We're not engaged in rendering legal, tax, accounting, or other professional advice. Should you require those services, you should retain competent advice from a professional in that field. And I have to say I apologize for the late notice you may have gotten today. Jim is the one that takes care of that, and he's had some issues which he'll talk about later. I still don't see him here. So anyway, as we all anxiously await the RV, we thought it might be a good idea to review what we've learned about asset protection. So, Judy, would you like to get started?
I would love to, Carol. So let me ask the simple question that we all ask: why do I need a trust?
Well, Americans with any wealth at all have at least one financial foe that they fear more than the tax man, and that foe is the lawyer. Many businessmen and professionals know the legal system is out of control, and nowadays it doesn't take much to convince a jury to vote to give you all of your assets to a sympathetic plaintiff. One mistake or even one unfortunate accident can take away all of the fruits of a life's labor. Insurance often cannot or will not cover an entire claim, and juries often award damages beyond the limits of the policy, forcing the creditor to look to your personal assets to satisfy his claim against you or your business. So think about this for a second. Because of proliferation, and I have a hard time with this word, because of the proliferation of the lawsuits and the potential exposure and liability so many face every day, successful professionals and business owners are putting a higher priority on asset protection and on tax avoidance. The common law contract trust organization is one of the few key ways to preserve assets from creditors and judgments from lawsuits. And why is this possible? Simply stated, if you don't own the asset, then no one can take it away from you. Prudent estate planning compels you not to own anything, and that goes against every grain that we've ever grew up with. You know, when we grew up, it was the more you have in your sandbox, the better off you were.
Exactly.
But asset management, not ownership, is the best method available to reduce risk of loss. You can do this by utilizing the common law business trust, contract trust. No insurance at any cost can furnish the protection that the contract trust can provide for you, your family, your goals, and objectives. Again, remember, sorry about the telephone. Remember, the secret of real wealth is not ownership control.
So, Carol, what exactly is a common law business trust?
Okay, hang on just a second. Jim just popped in here.
Oh, good.
Good morning, Jim.
Good morning. Sorry I'm tardy. I was on the other line. You know how that goes.
Okay, so Judy, what was that question again?
I was asking, what exactly is a common law business trust?
The common law contract business trust that we provide is an anomaly in asset protection vehicles. Its full name is Non-Grantor Irrevocable Common Law Contract Business Trust. You can see why we just call it a trust. The name describes it very, very well. And although this is technically a business trust, we try to refrain from saying business trust because it's confusing, especially to bankers and people like that. So we have dropped the name business. Non-grantor means you don't give anything to the trust. Instead, you exchange your assets for $21 and 100 trust certificate units. This is a tax-free exchange. Irrevocable means you can't change your mind and nobody can tell you to revoke it. Common law means it gets its power and right from the law of contracts, which is supported by the U.S. Constitution, which is a common law document itself. That right is protected by Article 1, Section 10, which states that no state shall pass any law impairing the obligations of contracts. A common law contract trust is a contract written in trust format. Contract business trusts are inherently different than any other type of trust. If you choose to investigate contract business trust, you need to start in the B as in boy section of the law library, not in the T as in Tom section. And a business trust is recognized by the Internal Revenue Service and by the courts as a UBO, or unincorporated business organization.
Oh, wow, that's interesting, Carol. I like what you said about a common law contract trust is a contract written in trust format. That's very, very easy to understand.
And so it really sets it apart from others. Yeah.
It does. Yeah, it does. From where does it derive its power, its privilege, and its benefit?
Not only from the common law, but from the laws of contract, which in our country are guaranteed, again, under Article 1, Section 10 of the Constitution. A contract trust differs from a corporation in that it does not receive a charter from the state giving it legal recognition. It derives its status from the voluntary action of the individuals who form it. Contract. Its use has been expanded to include the purchase of securities and commodities.
Oh, wow. So what's the difference between a contract trust and any other type of trust, Carol?
One of the most unique and I feel compelling differences is that with a contract trust, you get to be your own trustee. That boils down to a very important advantage. There is no one between you and your money. No manager, protector, or anybody else telling you what you can and cannot do. The contract trust is totally private and not required to be registered or filed in any state except Nevada unless one is actively involved in a business, thus guaranteeing your privacy and anonymity. The contract trust is an irrevocable common law contract business trust organization, again, that is actually a contract and trust format. And, you know, as I mentioned, irrevocable means nobody can tell you to terminate it. In a typical statutory revocable trust, like a living trust, the grantor, you, can change your mind about what you have granted or given someone right up until your last breath. The IRS has a clawback clause. In a financial or business setting, clawback may refer to a provision in a contract that allows money or benefits to be taken back if special circumstances arise. So the IRS may decide that because you still have total control, the assets of that revocable trust may be part of your estate when you die. With an irrevocable contract trust, you give up all the rights, title, interest to the assets, irrevocably. So it will never become part of your estate, and there's no probate, no inheritance taxes.
Wow. So, Carol, is this the same thing as a Massachusetts business trust?
Well, it is based on the Massachusetts Business Trust. And due to their commonplace uses in Massachusetts, they became known as Massachusetts Business Trust. The use of a contract business trust originated years ago to circumvent restrictions imposed upon corporate acquisition and development of real estate while achieving the limited liability aspect of corporation without all the rules of a corporation.
Oh, I see. So how is the contract trust created?
The contract trust is formed by the writing of the trust indenture. The indenture specifies all of the main parameters of the contract trust. In that document, the trustees are named, the powers of the trustees are specified, the trust certificates are issued, and generally all items are addressed that are reasonably necessary to start a business. Upon the completion of the writing of the trust indenture, it is signed, and the contract trust is a legal operating entity. There are two parties that participate in the formation of the contract trust, that being the creator and the investor-exchanger. The creator creates or initiates a trust and offers to exchange the property of the investor, issues the trust certificates, and appoints the first trustee. After these tasks are complete, the creator has no further duty or right to the contract trust. This part is all complete when we send you your personalized contract trust. Upon creation of the contract trust, the creator exchanges with the investor and exchanger and issues the trust certificates. The trust certificates have no value, and since the assets are transferred to the contract trust by an exchange, there's no tax consequence. Some have expressed concern that the common law contract trusts are irrevocable. Under normal circumstances, that could cause a problem. But common law contract trusts, as we mentioned earlier, are also called unincorporated business organizations. Contract trusts can be dissolved similar to a corporation, and the assets distributed accordingly. We've recently heard that banks expect a revocable trust for your exchange, one in which you are the grantor or exchanger and the trustee. The method by which we create the irrevocable contract trust also allows you to be the exchanger and trustee. Our trustees also have a lot of flexibility, allowing the trustee to do or not do absolutely anything an ordinary adult person can do.
Wow. So, Carol, I live in a high-tax state. Is there any way to legally structure my trust so I won't have this issue?
This is a common question, and some consider the answer to be a bit questionable, but it's not. It's a long-term business practice. Corporations, LLCs, and trusts have been domiciled in any of the 7 states and not imposed state income tax for a long time. Delaware and Nevada come to mind because they're very, very popular. All that is really needed is the actual street address, not a P.O. box.
Okay. What will the business endeavor of my trust, what would that be?
Well, again, a question we get often. My favorite answer is asset protection or estate planning. I personally like to say estate planning because everybody has to do that at some point.
Okay. Can I be the trustee of my own trust, and why do I want to be my own trustee?
Well, again, that's a good question that most people don't get. Because the contract trust is not a statutory trust, but is a contract to determine what you can and cannot do, you need to look within the 4 corners of the contract. As trustee, you are in total control. There is no one standing between you and your money. You know, I've been asked the question about the investor, exchanger, and trustee being the same person and the possibility of problems created by this relationship. There are numerous court decisions on the issue of investor, exchanger, or certificate holder being the same person. The following is a Supreme Court decision that addresses the issue directly. Quote, the legal title, possession and control of a property may, by declaration of trust, be passed irrevocably from the grantor investor to himself as trustee with the same effect as if the trustee receiving the conveyance had been another person, end quote.
Oh, gosh, I think this information is just also interesting. I feel very comfortable in having it all. But how do I get money out of the contract trust when I need it, Carol?
That is a big question. People ask me that all the time. You know, the trustees are given broad powers to make distributions in several ways. The trustees can declare a distribution to the certificate holders at any time. However, this is taxable income to the certificate holder. The trustees can and should be paid a salary for the services they provide the contract trust. The amount can be any number you're comfortable with. $5,000 a month, $10,000 a month, $1,000 a month, whatever. It should be enough to cover your everyday needs like groceries, utilities, medical bills, etc. Don't forget, you probably will not, once this RV occurs, you probably will not have any debt. So you don't have to factor in car payments and house payments and stuff like that. You can pay yourself weekly, monthly, quarterly, or annually. It is all up to you. But keep it reasonable, as again, this will be 1040, 1099 income to you. The trustees can be reimbursed for legal business expenses incurred by the trustees, such as business-related travel, memberships, continuing education, etc. You know, what about, you're charged with managing and growing your trust. So what about going on vacation and golf and tennis club memberships? You probably want to investigate some business opportunities and relationship, right? Most of these expenses are tax deductible to the contract trust.
Okay.
The trustees have the authority to lend money occasionally. If there is a loan, there needs to be a loan agreement and or a promissory note. If your loan agreement calls for payments, make the payments back to the contract trust. For example, consider a 10-year balloon note 2%. At the end of the 10th year, renew the balloon note. I'm sure we've all heard of a 30-year mortgage. Just remember, at some point in time, you need to start paying off the loan, even if it's just interest payments. Otherwise, the IRS could consider this forgiveness of debt, which is subject to gift tax. And while we're on the subject of IRS, we've all heard rumors that it may or may not be part of our lives pretty soon. We don't know. Even if your Treasury does take it over, we don't know what the tax implications of anything are going to be at this point. So all we can talk about is what we know now. Your first, or what we call the motherlode trust, can fund other trusts. This is what we suggest for purchasing high-ticket items like houses and vehicles. New trust owns a house or car outright with no loan payments. This is the best way to give large amounts to family and friends as well. And regardless of which method you choose, be sure to write minutes documenting your actions. The above methods of paying for services, reimbursing expenses, and making distributions and loans all fall within the guidelines of the Internal Service Internal Revenue Service codes as they stand now.
Okay. So, Carol, as a trustee of my trust, could I ever be held personally liable in the event of a lawsuit, judgment, or liens against me personally?
The trustee shall, in their capacity as trustees, not individually, have and assume only such liability as may attach to the trust organization's property and assets. So, no.
Okay. Thank you. I like that answer.
No.
Is it difficult to operate a contract trust?
The operation of the trust is pretty simple in its basic format. As with any business, the more complicated the business, the more complicated the operation. If you keep the operation scope of the trust simple, then the operation reporting is simple. One of the things that we have all talked about in the past is you are going to need somebody to help you. When this RV occurs, none of us individually are going to be able to handle us. You will need a competent accountant. You're going to probably need a wealth manager, et cetera, et cetera.
Right.
So operating the trust is not going to be difficult. There are only a few things that need to be done to operate the trust. It needs to have its own bank account. Those bank accounts are for the business of the trust. You cannot pay for your personal items from those accounts. The accounts are for the business of the trust. I reiterate that because it's so important. The contract trust has to acquire its own tax identification number, or EIN, which we will obtain for you. And very simply, this means no commingling of trust funds with personal funds. Very, very important thing to remember.
Right.
And the last operational requirement of the trust is that you need to keep minutes. For example, the contract trust, if the contract trust is to make a major investment, such as a piece of property in forming another trust, then the trustees must have a meeting and record the minutes. These are really about the only strict requirements of the operation of the trust. The contract trust that you receive from us has a complete operational instructions as well as over 250 pages of legal backup. All of our clients have access to our members-only website, www.indicatorinformation.com, which has just got a wealth of information for you, directions, minutes, all kinds of interesting things for you to learn.
Exactly.
And once you join us, we will give you an access code to it, and you can get in it whenever you want at your leisure.
Awesome. Thank you, Carol. So how much does a contract trust cost?
Well, our contract trusts are just still $14.95. We do offer a 20% discount for family members or a 20% referral fee for fully paid referrals. And we do accept all major credit cards. One thing we haven't really talked about today, and this has just come up, is our triple play. As I mentioned before, estate planning is more than just taking care of the money. It's taking care of other things as well. We provide a pour-over will, which states anything that you own at the time of your death goes into whichever trust you designate. It also provides for power of attorney. If you can't take care of your business for whatever reason, whether you're ill or in a coma or out of the country, somebody else has been appointed to take care of it for you legally. And we also have a health care power of attorney, which everybody knows at this point you need a health care power of attorney just to go to the doctors. If you don't have one, they'll give you a blank one, and all it really does is give them the right to treat you. One of the things that's very, very important at this point is planning. We need to plan. Jim, would you like to speak to that for a moment?
Yeah, I would. Thank you very much, Carol. Most people know that we've been expanding our computer system and getting everything ready, and John Newell was my business partner and mentor in the computer business. He passed away Thursday morning unexpectedly.
I'm sorry, John.
He is the state is. Here's the funny part about this, kids, and I don't mean funny, ha-ha funny, but more funny peculiar, is he and I have been in this business together since 93. And he gave me a list of all of his passwords and passcodes that's 6 months old and is not current. Even we made a huge error. So when Carol says planning is important, it is utmost important. And I'm going through that right now, trying to figure out how I want to be able to take over the business parts that he's been doing, because I can't get into his computer. And I can't do anything right now on some of the stuff that we were in the middle of. So John will be sorely missed. But, even he and I didn't have our act together like we should have. So at this point, we really, really, really encourage everybody to sit down with your family, talk about this stuff, get all the passwords, get them all in one place. You can put them in a file that you can do some light encryption on, so not anybody can get in there. Make sure your family has all the information, knows where the keys are at, knows can get into the safes. Right now we have 2 safes that John has. We don't know what's in them. We suspect what's in them, but we can't get into them. We can't do anything with them until after we get a death certificate and get that taken care of and taken to a locksmith to get them to open up these safes. And it's just a real mess. And he got a clean bill of health from his doctor a week ago Wednesday, and he died Thursday morning. I found him sitting in his chair with his cat on his lap and his Kindle open. He'd been reading a book.
Oh, my God.
Passed away. So there's the situation. We have, even us in the know better, didn't do what we're supposed to do.
Yeah.
So I really want to emphasize everybody, it's very, very important to get the family on board on this thing and get everybody up to speed and let them know what your wishes are. That I knew. We did have a medical directive. I did have power attorneys. I've been taking care of him for a while. He fought and won cancer 3 times. And so just everybody be prepared. That's all I can say. Just be prepared.
One of the things that we suggest when we send you your trust is, and I'm going to read to you in the welcome letter that we send out to you. To fully take advantage of your estate plan, we strongly suggest you share all of this information with your successor trustees. Advise them on where you keep your paperwork and key documents such as burial instructions, cemetery deeds, and military discharge papers. If applicable, you should have your marriage certificate for Social Security benefits. It's also a good idea to have a declaration or cover pages of all medical, dental, life, disability, long-term care, auto, liability, and homeowner renter insurance policies. Include lists and copies of savings bonds, stocks, and bond certificates if they've not been included in your trust, as well as copies and deeds and titles to any real estate vehicles. People should know where your currency is and how to get to it. In John's case, Jim knows where it is. He suspects it's in one of those safes he can't open. So it's very, very important because we never know what's going to happen when. Your successors should also have access to documents describing primary and contingent beneficiary forms for your IRAs, retirement plans, and other employer-provided benefits programs. You should also provide any mortgage, refi, or reverse mortgage loan information. If you have a safety deposit box, make sure your successor has the key and the location. And although it's not necessary, it's always a good idea to have an inventory of your household goods for insurance purposes. And this is a really big one here. Don't forget your digital estate. Do a complete inventory of all digital accounts and assets and assemble all the passwords. Jim and I have been harping on most of you about RoboForm for a long time. Somebody needs to have your main password to RoboForm so they can get into your online accounts. And so, I think that's pretty much bringing home the fact that, as Jim said, even we're not ready. So, just a little update there. Jimmy, have anything to add?
No, not at this point, other than you can even do it on video. You can sit in front of a camera if you don't want to take the time, and you could just go over everything that you want done. Well, that's what John did, so I have that. But the passwords, there was a letter, and we found the letter, but it was dated in June of 2018, and none of those work. So he's changed them, and he is very good about that. His estate is clean. We know where all the documents are at. He was meticulous with records. It was easy to find, except he just didn't give me the passwords. So he gave me the location of the hidden cash in the house. Wasn't much, but there was there. And he gave me the PIN numbers to all of his checking accounts. He says, drain them out before the government gets a hold of it, which we didn't do because his son's involved in this, but there's not much in there. But he had a good sense of humor about it. But it's staggering what we have to go through suddenly with an untimely demise. I mean, that man was 66.
Oh, my God.
This
and
was
no
really
health issues?
Well, he had been fighting cancer. He won the battle with cancer. He got a clean bill of health from the doctors. He was up at OHSU last Tuesday, a little over a week ago. Called him on Wednesday. Says, we don't need to see you for 6 months. Everything looks fine.
Yeah.
And 8 days later, he passed away.
My goodness. Oh, my goodness.
So,
we don't know exactly what. But
yeah. So even if it isn't death, I mean, somebody may have a stroke. Somebody may be in a coma, whatever. So you need to be prepared for all these things. So on that note, I would like to actually open it up for Q&A. I did see, I don't see anybody right now. But Gary, did you raise your hand earlier? I thought I saw you there. Okay, well, maybe we'll just talk about some of the things I've gotten through email. Let me open this up here. Oh, there we go. There it is. Hi, Gary. How are you?
I'm good, Carol. How are you?
We're doing well, thank you.
Very good. Jim, I'm so sorry to hear about your business partner. That's awful. I'm very, very sorry.
Thank you.
I didn't really have a question right now. I was trying to get on earlier, and I was trying to say, hey, can you hear me? Can you hear me? And nobody could hear me, so I didn't know if it was on mute or something. And so that was the only reason I had put the *6 in to unmute myself. But I don't have a question at the moment. But the information you've given today is excellent. It's very, very good.
Thank you. We felt it was very timely. Thank you.
Yeah, I will talk to you later on, but I don't have a question right now for the masses.
Okay. All right. Thanks.
Thank you.
Okay. Hello, Dean. How are you doing today?
Hello, Carol. I'm doing fine. My question is on that new shipping location, which was Shipping Plus, 325 Front Street, Creviston, Wyoming. The letter that you said, what was we supposed to put in that letter that when we opened that account to send, for them to send back to us unopened?
Jim, you want to talk about that?
Yeah, I've got it on the website. I don't know exactly where it's at, but I did put it on the website, but I can email it out. We probably should get that out again right away. It's a simple letter. All you want to do is send it, return receipt requested, so you got the green card. And you want to put something to the effect in there that, on this date, this trust is now domiciled in this state by our choice. And for anybody that's opening this letter, this is to let you know that this has been domiciled since the postmark on this letter in that state. It's just a way to prove to the court that, yes, your intention was to be domiciled there. And here's a letter that's unopened that you hand to the judge, but you've got the green card to prove it was sent to that box. And you produce all of that to him. He'll open it and see that, and he's going to have to rule in your favor because you did go the extra mile to prove that you were domiciling that state, domiciling intentionally in that state. That's all you're trying to do, is prove to them that it was forethought and you did it properly.
Okay. Thank you, Jim. Also, on this, we just call them or contact them and tell them we would like to have a address there and just forget our other one, that the box.
Carol, I think Carol would agree with me on this. Yeah, you can just change. Just call them up and they'll send you the information. They do it over the phone, most of it. They may send you a form to fill out and sign, send back, but they've been opening boxes right and left there in Evanston. We have a place in Vancouver that's very good too. So however you want to do it, when it comes due, next time that it comes due, you want to let them know at the one in Cheyenne in advance that you don't plan on renewing it. Because
they have billed some people ahead of time, right?
Yes, they have, and they won't give them the money back. So we are...
Well, that's not nice. That's not
nice. I know. And we help these people for a while. Anyway, So we've moved everybody to suggested another place. Either they're in Evanston, we've had great luck with these people. They're just phenomenal. They work with us real well. And they'll put up to 5 or 6 trusts in one box, where the people in Cheyenne only give you one trust per mailbox. It's just ridiculous. You're getting one piece of mail a year.
If that.
Yeah, if that. And this is a situation where they're making good money for doing nothing. So,
would you suggest that I go ahead and cancel the box and then renew the other one, or renew the other one and wait till the box one is due?
Well, that's a call that you have to make financially. If you're happy where you're at right now, go ahead and send the letter, and that way you've at least established it. When the box is coming due, know full well that you're probably going to have to change, and give them plenty of notice that you intend to change to a different place. And then I'm sure that Evanston can facilitate, a lot of customers. They've got a pretty good size outfit there. And then just move it then. That's what I would do personally. I wouldn't bail on one that I've already paid for. No sense in it. But
okay.
I don't think I would suggest renewing there because of the way they've been handling some of the customers.
Thank you.
There is one requirement, possibly 2 requirements when you do change address. You have to file a form with the IRS, 8822B, and we have the link to send you. I think it's on the website also, isn't it, Jim?
It is. And don't fear the form. The form is nothing more than you put your name, where you want to move it to, the name of the trust. It's like 4 or 5 lines. And you just send it off the IRS. The moment it's postmarked, it's effective, because when you send this off the IRS, it's just a administrative change. It's not a change in the status of the trust, just a change in location. And then it
is changing the location of the business, not just the mailing address.
Right. You're changing the domicile.
Yeah.
Now, it can be just from Cheyenne to Evanston, but you're still changing it.
Right. However, if you change, and you don't have to note that in the minutes if you don't want to. However, if you change from Wyoming to Washington, you need to write a minute that the domicile was changed to blah, blah, blah. And actually, that is in your sample minutes, because we suggested that some time ago.
Yep.
So that's something you don't really need to worry about. I mean, you need to do, but it's not a big deal.
Okay, thanks a lot. Do you know, is U.S. Bank a Tier 1 bank?
I read recently that it was. But I can't say for sure, but it seems to me I read recently that it was now a Tier 1 bank.
Okay, thanks a lot.
You're welcome. Okay, we have one more caller here. Area code 707, Jackie? Or is that James?
It's James. Yes, it's James. Hi, Carol. And Jim, it's good hearing your voice. It's been a while, so we're really glad to hear your voice. A quick question. We had a meeting about a week ago. There were about 3 of us in our Northern California area. And one of the questions that came up is, should a house, if you own a house, should it be put in the trust now, or should we wait till after the revaluation? The reason that came up is because the owner, one of the members that owns the house, was concerned that if they got into some kind of lawsuit or somebody got injured in a car and then their assets were sued for their assets, that they could assess that house. So they were saying, well, should I put the house in the trust now? And because they still have a note on that house. They still have to pay a note on that house. We were saying, well, for your protection, you probably should. And then they said, well, if we put the house in the trust now, we don't own the house anymore. The trust owns the house. So how would we pay the house note? Will we pay the house note in the name of the trust, or will we send the check directly out of our account? How would that work? So that was the question. I didn't have the answer for that.
Well, first of all, you have your mother lode trust, right? And that just contains your currency, and that's all your mother lode trust should ever have, and it is your currency and the required money.
Okay.
If you're going to purchase a new home, you're going to purchase it in the name of a trust. But putting an existing home, even with a mortgage on it, into another trust is not a big deal. What you're putting into the trust is the equity. It's the part that you own. But you still have the note, right? Your name is the one that's on the mortgage or on the note.
Right. Okay.
So
they could act.
Go ahead.
I don't want to cut you off. Go on. I'm sorry. Go on.
So, from what we've all heard, when you go to your exchange, should be able to request a few cashier's checks or wires, bank-to-bank wires. You could probably request a wire to pay off the mortgage amount from there.
Mm-hmm.
And I don't think the bank's going to care if it's in your name or your trust name.
Well, that would be post-RV, though, right?
Yes.
Okay. I just want to make clear. I thought they would be on the call this morning. They're not. So the response then is they have to get another trust to put that house in. If they want to put it in there now, they have to get a separate trust. And if they want to make the payments on the house, they could make those payments from their regular, the checking account that's in their name, but the house will be in the trust, in the new trust. Am I on the right track?
Well, the only concern I have about that, and Jim, maybe you can help me out with this, is the tax consequence of you taking the balance of the mortgage money in your own name and then trying to pay it. I think if you paid it ahead of time, at your exchange, it would still be under the non-tax part. What do you have to say about that, Jim?
Well, I would agree with that. Whenever you take and put a house in trust, it's done all the time, and they usually think they're just living trusts. That's what they think they are. Sometimes they're not. There are types of trusts. And you just continue making payment. Because the only thing, you're still on the hook for the loan. And the bank still has the collateral of the house. You're just taking the equity and you're putting it in a trust, basically, and you're protecting yourself. One of the unique things about having everything in trust like I do, card and everything, is if I do have a major screw-up, they can't sue me personally. I mean, they can go after me, but they can't get my assets because it's whatever they're suing was actually in a trust. And even your currency is personally owned by you until you put a trust.
Right.
So, if they are going to go after you and sue you and try and get things, you might want to make sure you've got everything set up in advance because your currency is at risk.
Right. Okay, well, that answers my question. I appreciate it. Thank you very much.
Thank you, James.
Okay, bye-bye.
Bye.
Audrey, thank you for joining us today. What's on your mind?
Hi, this is Audrey Clark, and I'm trying to figure out. There's so much information on this call. Is there some way I can either go to a website or listen to the call again and get the information over and over until I really understand what I'm supposed to be doing? This is all new to me, so I'm probably going to need a few runs of this.
Probably. All of our calls are archived.
Okay.
And if you look at the bottom of the emails that we send you, it's got the live call-in number and it's got a playback number.
Okay. Right. Mhm.
And you are a client now, so that, as I said, if we haven't already sent you the link to the website, we will. I'm sure you've already done that, right, Jim?
Yes.
Yeah. So just go to the website, sign up, go to the website, and there's just a wealth of information there. Okay.
Is that in the packet, the priority mail that you sent?
That was in the email. I sent an email to everybody. I said that your box had been shipped, and in there it's got a one-time access code and tells you where to go on the website to enter that. And then what you do is you create your username. You sign up. It'll ask you your address, things like that. And then it'll send you.
Because I'm not sure if I got that email.
Okay. Well, if not, just email me back and I can send it to you again.
Okay.
But anyway, the thing is, once you get it set up in the website, all that information is in the website. We're adding more to it all the time. The website's on the new server. It's not quite as fast as we thought it would be right now because it's on what we call a temporary server. Although it's ours, it's not located yet up in Boardman. It's here, local in Salem, where we do the development. And that was one of the things that we wanted to do is get the local development done. And then, of course, John passed away the other day, so now I've got to deal with that. Okay. So I don't know where all this stuff is at. And he was taking care of that for us. But I'll find it, and we'll get this finished up. But
I think I'm going to want to open up other trusts for different things I have. I have property, I have quite a bit of property. I have things that I want to invest in, and I want those to. I think I should be putting those in a trust under the main trust.
I agree with that.
Okay, how do I set that up? Because I'm kind of moving pretty fast here, especially with the property. I'm actually thinking about putting it up for sale, and I want any of the money to go into the new trust.
Okay.
I think that's what I'm doing with it.
I think it's a really good plan.
Yeah, I was sitting here thinking probably what I should do is give you a call the next day or so, Audrey, and just talk with you for a while.
Okay, that sounds good.
It's going to be a couple of days. I've got, when we get off the phone call today, I've got to go over and start helping out at the house.
That would be fine.
And then, so I'll probably be Monday before I get with you.
Okay. It's just I have a lot of property. And in this state, I have property that still has one piece of property in North Carolina that still has a mortgage. So I've got, some that have already been paid for. I've got some that have a mortgage on it, and some I'm getting ready to purchase. So I need to kind of know what I'm doing with it before. What is your recommendation before I actually do these things? Before I purchase and before I sell, I want to make sure I'm doing the smart thing.
Well, we'll sit down and go over that and come up with some solutions for you and some recommendations, and then you can make your decision from that.
Okay, thank you.
Yeah, so I'll be giving you a call first of the week, and I'll email you in advance, let you know what time frame, then you can email me back if that'll work, then we'll just jump in on the conversation.
Okay. You have a great day. And then you can maybe check that and make sure you've emailed me the code that you were talking about that I should have.
All right, well, I can go ahead and I'll look while we're talking. I'll let you know here in just a second.
Okay. Well, I'm finished.
Okay.
All right. Thank you, Audrey. Those are really good questions.
Excellent questions. Wow, what amazing questions.
Okay,
all right. Daphne, my dear, haven't heard from you in a while. How are you doing?
Hi, Carol.
Yeah. Hi.
Hi, Jen.
Hello.
You sound great, and I'm sorry about your friend.
Yeah.
I hope all is well with that.
We all got to go that direction. Just some of us go unexpectedly.
Yes. Well, I have some questions in regards to the domicile deal. I've been out of the loop for a while, but I wanted to know, was there anything sent in regards to the new domicile information?
I don't know. I think we've just mentioned it on a call, didn't we?
Right, and it's on all of our literature now. It's on our website. We can email it out to you directly.
Okay, I'd appreciate that.
Okay.
I did notice that with the other one, the lock shop, even though we were paying a certain amount for the year, and yes, they have increased it, but they were also charging to send mail out. So, and what I noticed from the last time they sent it, the people that were sending it to them to send to me, all of a sudden I got it directly from that company. And so I called to inquire about it, and I still have a balance on file in regards, I guess, towards renewal or whatever, which I won't do. That's why I'm inquiring about the information as to the new place that we should go to, okay?
All right. Carol, you have her email address?
Yes, I do.
Okay, we'll make sure that gets out to you right away.
Okay, thank you very much. It's been an awesome call. You did answer some questions in the beginning, because I had people who were concerned about being able to write business checks out of the trust to pay for bills, things of that nature. But the mother load is different, so they would need another trust to handle or whatever else they were doing, right? Like for the car or for the house that was mentioned earlier.
Mm-hmm.
But you're saying they can pay it from their personal account, as they've been doing?
All right. What I'm suggesting is that you want to pay off a mortgage or a car loan, and at the time of your exchange, we've all been told or have heard that we should be able to request up to 7, I believe, wires and or cashier's checks. I would have the amounts ready then.
Okay.
I need a wire transfer for $247,000.87 for my mortgage company. Here's where you send it. If you were to take that money personally to put it into your personal account, it would become taxable to you.
Mm-hmm.
If you do it at the time of exchange, from what I understand, it will not be taxable. You agree or disagree with that, Jim?
I agree.
Okay. Okay. I'll sit back and listen to the rest of the call. Thank you.
All right. Thank you.
Mm-hmm.
Let's see. Well, we don't have anybody out that has their hand raised for the moment, but I have had some email questions recently, so let me read them to you. Lately, I've been hearing that the banks are going to offer a POD, pay on death, or TOD, transfer on death, to sign. He said it's not mandatory. I just want to make sure with you that I was under the impression that if I signed any of those, it would null and void the trust. So I'm just double checking because I don't want to sign either one of these documents. Well, I'm not so sure about nulling and voiding the trust, but I checked with my banker about that specifically several years ago. And he told me that seeing how we have named a successor trustee on our abstract, we will not need a TOD or POD.
Oh, wow.
Yeah.
Wow. So if you have a bank account attached to one of your trusts that has $17 million in it, you don't have to, that money automatically gets, quote, assigned, unquote, to the successor trustee?
When you die, and Jim, you can probably talk about this right now, your successor trustee walks right in and takes over, period.
Okay.
Wow. Yeah, they'll probably need a death certificate like Jim's been talking about.
Right.
But your successor trustee takes over. There's no waiting. There's no attorneys. There's no courts. You've already named that person. You just go in with the assignment of the successor trustee and a death certificate, and you should have no problem whatsoever.
Okay. Do you think that it's overkill, Carol, in your opinion, and Jim? Do you all think that it's overkill? I mean, would it add another layer of protection if you did have a POD who is the successor trustee of your trust? Do you find that harmful in any way, or is it just another layer of protection?
Well, the question that I was asked, if I was under the impression if I signed any of those, it would null and void the trust. That, I'm not familiar with that at all.
Right. I don't see how it could.
I don't see how it could either. I don't see how it would hurt to have it. Do you, Jim?
No, I don't.
Yeah. Okay.
In my particular case, which is personal but probably applies to other folks on the call, I have many grandchildren, and the one I'm going to name as my successor trustee is now 20, extremely fiscally responsible. She and I have had a long conversation about the responsibility of being a successor trustee, and while she's willing to do it, she wants me to be able to teach her how to do what I want her to do, which I think is easy to do, but I would want her to be the POD on my bank accounts, all the bank accounts as well.
I mean, if it makes you feel better to have that person named as a POD, I don't see why not.
Yeah. Well, now that you've raised the question of would it make the trust void, how can we find out how can we find out about that?
I would ask your banker.
Okay, I'll do that. I'll do that on Monday, and I'll get back to you with the answer.
Okay, that'd be great.
Because my private banker is completely familiar with all the trusts that I've already got set up, and she knows me personally, so I'll ask her.
Okay, good plan. Okay. I still don't see any hands raised here, so I'll read some more. Okay, one of the callers talked about filing taxes, and you made a good point. I never thought about writing an invoice to the trust for what I've paid out so far. And what you're talking about, and I probably have mentioned this on an earlier call, you should be able to deduct the cost of your trust. And anything you've done for it should be tax deductible to the trust. And just want to make sure, along with the cost of the trust and the cost of the P.O. box and the office supplies I purchased for the trust, can I also invoice the trust for the currency that I purchased? Well, that's a really good question, but think about this. You cannot build the trust for the currency because you exchange something of yours, in this case the currency, into the trust for trust certificates. You can't then go back to the trust and say, I want to be reimbursed for that. Because you've already exchanged, the trust already owns it. So you cannot charge the trust for the currency. Let's see. I still have to write my minute about currency I purchased in the month of March, which was after I purchased the trust. Do I have to make another schedule a day for that currency, or just put them on the schedule that you have in the trust? Do not ever use Schedule A. It's for the initial exchange only. What you have on there is some currency listed. Do not ever put anything else on there, any dates, anything else. The currency is for your initial exchange, and if you do purchase more currency, use a sample minute that we've attached with all of your. It's on the website. It's already on the USB or on the CD that you have received with your trust. It's just do not ever use Schedule A again.
Excellent question and answer, Carol.
Okay, let's see. I'm trying to see if nobody else is raising their hand, and we've got a few minutes left.
Well, let me jump in real quick.
Please.
Audrey, I did send that. I sent it again to you. It's on its way. So we were having email problems with that particular day, it looks like, and Carol can vouch for that one. We've had some real email problems. Anyway, it's on its way. I think everything will go through this time without any problem. We've got a new server, so let's hope. That's all.
Really. Okay, I would like to have my memory refreshed concerning depositing money monthly, quarterly, etc. to my children's account without them nor myself having to pay any taxes on the money. I hear there is not a limit. Then I've heard $14,999. As of last year, the 2018, the gift limit is $15,000 per year per person. The only way you're going to be able to give anybody a large amount of money up front is to create and fund a new trust for that. And we've talked about that. Judy's talking about her granddaughter. At some point, she may want to just give her granddaughter a bunch of money. So
to pay off for student loans. Exactly.
Yeah, create another trust, fund that trust, stay on as trustee until you feel that person can handle it, and then you retire. Right. We have Jim and I have both spoken to some of our clients that have multiple children, and they want the same thing. How am I going to give them a bunch of money? That's how you do it. Fund another trust, stay on as executive trustee, keep them as trustees, so you still have to agree on everything. They can't just come and say, Dad, I need $15,000 to do something. Well, no, we got to talk about it. And when I feel you're ready to manage this trust on your own, then I'll resign. Until then, you got me.
Yeah, exactly.
Yeah. So, go ahead,
I'd like to ask a question of you and Jim, if you have heard of this. What do you know about? In my case, I have grandchildren who I would like to pay off their student loans. I've been told that as long as I pay the loan company directly, it doesn't create a taxable event to the grandchild who has the loans. Do you guys have any experience with that?
I have read the same things. Paying off education bills directly to the institution, or in this case, whoever funded the student loan, and right. Medical bills are not taxable events. You have to pay them directly. You cannot pay the person.
Did you just say medical bills as well?
Medical bills as well, yes.
Okay. Thank you.
You're welcome. Okay, we do have another. Go ahead, Deb.
What about IRS bills?
I don't know. I mean, I think if you try to pay off somebody else's IRS bill, that might cause a taxable event. But I don't know.
Mhm. Okay. And as far as the children are concerned about the trust, what about a spendthrift trust?
We do have a spendthrift clause to add to your account. To your successor page. Mm-hmm. If you got your trust some time ago, or now you want to add a spendthrift clause, we can actually just do that in a minute. And that spendthrift clause is on the website, so you can write it yourself.
Oh, my God, that's outstanding.
Yeah.
Perfect.
Okay, thank you.
Okay. All right, we do have a couple hands raised here. Larry, welcome to the call.
Hi, Larry.
Hi. I've really enjoyed the presentation.
Thank you,
Carol, and you, Jim. I'm sorry to hear about your friend passing. That's terrible. And, of course, good to hear you on there, Judy.
Thank you, Larry.
I've had telephone problems this morning. My phone, which comes in on the TV cable, we're having snow here, kind of blowing and all, and my phone was not working earlier, so I had to use the wife's cell phone. I don't own a cell phone, but I used that early on to listen to everything that was presented, and I certainly enjoyed it. It's very professional and all, and some good advice. Some things that I know and some that I don't, but anyway, I just wanted to stick my head in and say that and then run back out. But I've really enjoyed it. Thank you very much.
Well, thank you.
You're welcome, Larry.
Yeah. Okay, we've got another one here. Bill, area code 240.
Hey, Carol and Jim, this is Bill. How you guys doing?
Doing well, thanks.
Good. I appreciate everything you guys taught me on trust. I learned so much from you guys. Jim, I'm sorry to hear about your friend as well. I just got two quick questions. One is on taxes, because you mentioned taxes or the IRS, and I think you've said this before. I guess I just need to hear it again in reference to filing your taxes on your trust. I think you said the maximum income required for my trust is $600. Otherwise, it would technically, if it's under that, it would be zero income. I'm not certain of that, so I'm asking because I'm not sure whether or not this still needs to be filed or it should be filed regardless.
Jim?
Well, IRS. We hate IRS. Okay. If I have income over $600 in the trust, I file. But right now, I don't.
Yeah.
So as long as I don't take in and create any commerce in excess of $600 for the particular trust, no, I won't file for anything. It's not necessary.
Okay. Yeah, I agree.
Yeah, I was wondering about that. Okay, because otherwise it's basically zero income, or it's considered that.
Correct. You still have to file your year-end minutes, regardless.
Yes, which I've done that already.
Good.
The other question I have is in reference to the site, because you mentioned that we were moving to a new server, I believe, because I tried to log in today, as a matter of fact, and it's coming up saying it's giving me some sort of error message that I cannot connect to the server, or it's saying it's not secure or something. And I went to indicatorinformation.com, unless that's the wrong address.
Well, that's the right one. I'm logging in now. I haven't been on it this morning. It's working for me, so it come up pretty fast, too. You know, there are times in the Internet that things just don't work right, but it's working for me.
Okay.
Let me go here and try and log in.
For some reason, it's still coming up that way for me. I don't understand that.
Maybe he needs to reboot his computer.
Well, either that or you clear your cache.
Okay, I could try that, because I had no problems before.
Right.
So
it
maybe
was.
it's on my end.
We are on the new server, and it's not in the location that I want it in yet. It doesn't move up to Boardman for another month, so it's actually local here while we develop this.
But the address.
I'm in the back office. Everything looks good. I've logged in, so clear your cache, see if you can figure out what's going on.
Okay.
And I'm doing a bug test right now. No bugs.
And the address hasn't changed, correct?
No, it's just indicatorinformation.com.
Okay.
Now, let me try something here in a second. I wonder if John finish to what he said he was going to do on this URL for us, Carol. Let's see. No. Okay. We're going to have a short URL set up for this very, very shortly. And we didn't get it done. It's not done, but I will get it done probably later today or tomorrow. But just for everybody out there, it'll be the number 3, the letter I, and the word trust.com. 3itrust.com is going to be a shortcut. Instead of typing indicatorinformation.com, you can just go 3itrust.com. It will go to the website later today. I've got it started. It just hasn't populated through. I'll try and get that done. That's one of the things that John and I was working on Thursday.
Okay.
So, anyway.
So I think I discovered what my problem was when I typed in www.indicatorinformation.com. It changed it to https://www, and that's when it came up like that. So I took out the www, and then it comes up.
Okay, it's for everybody out there. You don't have to put the www in front of most, including our websites anymore, because it's an antiquated way of doing things. So just type it in the address bar, and then indicate information, and it'll come up. And then the 3I Trust, the reason it's not coming up is I haven't issued the certificate to it yet to make sure that everybody gets the right information.
Okay.
So I'll go and try and finish that up today or tonight.
All right. Well, thank you. That's all I have.
Okay.
All right. Thank you, Bill. We've got another question. James is back. Hi, James.
Yes, I do. In our meeting, another question came up, and that is, if a person has an existing IRS tax obligation, and then the RV hits, should they pay that obligation off before they put all their funds into the trust? Or should they just go on and put their funds in the trust, and then could the trust pay the tax obligation?
No, you're getting into an area that, we're not accountants. We're not tax people.
Right, no tax.
Yeah. Jim, you have a comment on that? Because I'm not really sure.
Well, I'm not either. We don't know what the status of the IRS is going to be when that happens.
Mm-hmm.
Hopefully, there is a bill before the Senate right now to abolish the 16th Amendment and revoke the IRS. Let's hope it goes through. But right now, I would. They're not going to do a whole lot to you initially. They're just going to be looking. Mm-hmm. So I would. I'd pay any tax liability that you have. I'd pay it off as soon as you can.
Yeah. And I would pay it personally, wouldn't you?
Yes, I would. I would do it.
Absolutely.
Yeah, I wouldn't do it through the trust.
Exactly.
All right. So I guess what I'm saying is, like, let's say a person has, this is hypothetical, let's say a person has $1 million in revalued currency. Should they just, instead of putting the whole $1 million in, should they pay the tax obligation and then what's left over after they pay the obligation, then put that in the trust?
That's what
I know you're going to be taxed. I know they would be taxed because the money would be coming directly to them and it wouldn't be in the trust. But what they're trying to do is they're trying to dispose of the tax obligation before they put the money in the trust. And so I guess that's
well,
go ahead, Jim.
It's kind of a chicken and egg issue. Personally, if I had a tax liability, I would take the money out of the trust after the RV, the same day, and I would take it to my personal name. I'd pay a little bit of tax on it, and then I would pay my debt.
Yeah.
Because it's not the trust debt, it's your debt. And so you should be in your name, and you should be able to document that you borrowed the money from the trust, or however you want to say it, and then you paid your tax liability in your name, not the trust name. You don't want to drag that entity into this.
Exactly. I like that idea of borrowing the money from the trust to pay it. Because then,
and then pay yourself a promissory note, balloon in 10 years, so on and so forth.
That makes sense. Okay. Hey, thanks a lot.
All right.
God bless.
Thank you.
Bye-bye.
And Daphne, you're back. Daph? Oops. Okay, there you are.
This is Daphne again. You answered the question. My suggestion was going to be if they could get a loan from the trust to pay the IRS bill. So you answered it. Thank you.
All right.
All right. Thank you. Well, folks, it's a little past the hour, and I think I don't see any more hands raised. Thank you again, Judy, for your able assistance as always.
My pleasure.
And thank you all for your attention and attendance. My name again is Carol Werelius. You can reach me at 425-820-8090 Central Time, typically between 10 and 6, or at indicatorinformation.com. Jim, would you like to say something to close?
Yeah, thanks for your condolences. Loss of our friend. He's been with us since '93, working with Carol and I for years. And he was my ex-partner in business and just my closest friend. And he was in the business with me when we had our office in the Bahamas. And
oh, wow.
Yeah. So, he was very knowledgeable about this stuff, and he was coming back on board to help us get all this website done. He was excited about it, and he was working with us. It's just one of those things. We don't know exactly what happened. It was a real shock to all of us. And we're going to use this lesson. John would be thrilled about this, about how we were unprepared for a certain issue when we're supposed to be the ones to do it right the first time and every time, and we screwed up. So we're going to take and preach about this, and we're going to talk about this many times about, okay, remember when John did this, and John and I had this issue. We're going to use that. We're going to use that as a way to build. And with that, I'm going to sign off. My name is Jim Knox. You can get hold of me at 503-583-6791. I'm on the West Coast. I prefer not to be disturbed too early. I try and start around 9 in the morning, and I'm trying to get done by 7 in the evening. So give me a little slack for the next 3 or 4 days. I got a lot of things I got to catch up on, but then give me a call if you have anything. And Audrey, I will be in touch with you. That's all I have.
Okay, thanks again, everybody. Let's go RV, and we'll talk to you in 2 weeks.
Go RV. Thanks,
Bye-bye.
guys. Have a great weekend, everybody.
Bye now.
Thank you. Bye-bye.